Hi folks, Tony DeWitt here, Missouri appellate attorney, retired, and a guy who just likes to try to make the law make sense for people like you. There's lots to get into today, so let's dive in. I'm going to talk about something pretty serious today, but before I get there, I want to say something that I think is very important. If you or your child has some kind of emotional problem, you need to seek help, or you need to seek help for your child. The last thing in the world we want to see are children suffering from mental disease or mental defects causing harm with other people. And I point that out because there are a number of options available to you as a parent to get help for your child. I'm going to put a few of them up here on the screen. Today I'm going to talk about the incident that occurred in Georgia at the high school. Appalachee, I believe, is the name of the school. And I'm not going to mention what that event was because I'm sure all of you know about it. I am going to talk specifically about the charging decision with respect to the father in that case and whether or not it was correct. And clearly, I believe that it is correct. As you all know, I am a strong supporter of the right to self-defense and the tools and implements necessary to give you an advantage in self-defense. But when someone uses what should be a defensive tool for offensive purposes, they lose the protection of the Constitution and pretty much every other form of law other than their right to a fair and appropriate trial. The father was not directly involved in the action at that school, and as a result, there is at least an argument that he should not be held accountable for the actions of his son. But just as the parents of the incident up in Oxford, Jennifer Crumbly and her sometimes husband were responsible for the actions of Ethan Crumbly, the father should be responsible for the actions of his son here. And here's why I feel that way. There's some body cam footage I'm going to show you from where the sheriff's office went out to talk to the dad about the event. And the question was whether or not this young man had made statements to the effect of what he was going to do, what he ultimately did. And this is what the father promised after having that conversation with the Jackson County Sheriff's Office.
I don't know anything about him saying like that, and I'm going to be mad as hell if he did. And then all the guns will go away, and they won't be accessible to him.
And you may note that I am not mentioning them by name again because I don't desire to give them any more publicity than they've already obtained, which is way too much in my book. The more these are publicized, the more other people with some kind of mental pathology get the idea that this is a way to make a name for themselves, and the people who pay the price for that are average citizens. If the father had done all of the things that he should have done, I would be less inclined to believe that he should be charged in this incident. If he had, for example, secured the tools used by the child, then he might be in a better position. If the child had had to break into a safe or a storage cabinet, if he'd had to use a crowbar to get access to the things that he used, then maybe you could develop some kind of defense on the basis that the parent had done everything that they could, even though I doubt very seriously if that's the case, because somebody had to teach that individual how to use those tools, and I strongly suspect that that was the parent. Now, the mom and the dad were divorced, as I understand it. The mom was worried about her kid. She called the school that day. She tried to alert them. If they had not bungled that at the school, they might have been successful in stopping this. But, coulda, woulda, shoulda. Who knows? If ifs and buts were candy and nuts, we'd, have a great snack tray. The problem with going back in time and saying if, the issue with that is it doesn't help anybody, and it doesn't satisfy the requirements of holding people accountable. And people do need to be held accountable. Why do they need to be held accountable? Because clearly the message didn't get across with Jennifer Crumbly and her husband. It didn't get across because otherwise this would not have happened. There would have been measures taken. If you have a child and that child is not themselves, if they are acting in a way that is different, the last thing in the world you want is any kind of tool that can be used to harm others left laying about. I would further point out that if you have a child who is socially awkward, doesn't have a lot of friends, doesn't have a peer group, you don't see him with the same kids or with the same normal kids that you should see him with. You see him with other misfits and people who don't belong. That's a big clue. You need to pay attention because that child may have some mental pathology and it may not really even be his fault. It may be the peer group that he's hanging with. And so it's very important to actively parent, particularly in the teenage years, and be aware of what your child is and what he's doing. And for heaven's sakes, this is the last child that you buy one of these defensive tools for as a Christmas present or a birthday present. No, 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 no. Our daughter, who is a pediatrician, refers to this as means. In other words, means security, securing the means to harm other people. You put up the implements that go bang. You put up the long kitchen knives. You take away pocket knives. You make sure that matches and other implements that could be used to cause trouble are removed from that person's immediate grasp and lock them up so that they can't be obtained. You do that so that you protect the child and you protect all of those people that he might be inclined to hurt. Now let's talk about the legal justification for charging the parent in this particular instance. And to do that, we need to look at the Georgia statute. Here's the Georgia statute. A person commits the offense of involuntary manslaughter in the commission of an unlawful act when he causes the death of another human being without any intention to do so. Well, here we don't have him committing an unlawful act. That's because Georgia does not have a safe storage law such that it would make it a criminal offense to allow a minor to have access to one of these tools. And for that reason, paragraph A doesn't work. Paragraph B, a person commits the offense of involuntary manslaughter in the commission of a lawful act in an unlawful manner when he causes the death of another human being without any intention to do so by the commission of a lawful act in an unlawful manner likely to cause death or bodily harm. A person who commits the offense of involuntary manslaughter in the commission of a lawful act in an unlawful manner upon conviction thereof shall be punished as for a misdemeanor. Well, not exactly what you would call a strong incentive to avoid negligence in this particular case. I am sad to say that it is this portion of the statute that I have highlighted here, in an unlawful manner likely to cause death or great bodily harm, that is going to be the biggest impediment to the state of Georgia holding the parent accountable here. Because it is not unlawful to fail to supervise your child in his daily activities. It's not unlawful to have those tools in your house. It's not unlawful to leave them unsecured. So there's no commission of an unlawful act, and there are likely thousands, maybe even hundreds of thousands of homes in Georgia where people leave these defensive tools out all the time, unsecured, without anything to prevent their misuse, because they have taught their children to respect those tools and not to touch them and not to mess with them. The reason it's a heavy lift is because the statute says in an unlawful manner likely to cause great death or bodily harm. Where is the unlawful manner? Leaving the tools out? Again, hundreds of thousands of people do that every day in Georgia, and nothing bad happens. The way they get to it being an unlawful manner is essentially parental negligence, parental malpractice, whatever you want to call it, they have to basically prove that the parent knew that this child had a problem, knew that he was having the kinds of thoughts that he shouldn't be having, and he acted on those thoughts because he wasn't getting enough attention or supervision from his parent. Now, like I said, I think it is a pretty big lift for the state in this case, but we'll have to see. In this particular case, what the state's expert would need to do would need to be able to show that it was unreasonable in the extreme to allow this young man to have access to those tools for any reason, even to go hunting, even if he said, "I'm going hunting after school." I guess I should go to editorial mode. This is one of those situations where I sometimes think there ought to be a requirement to pass a test before you can have children, because so many people do it badly. They don't supervise their children. They don't teach their children. They don't sit down and talk about why we have to be kind to people, why we have to respect their rights. When someone says no, it means no. You don't do the kinds of things that are unkind and uncalled for in a situation. If a child does not have a good social education, meaning understanding how human relationships form, how they work, what to do and what not to do, you wind up with this kind of thing. You wind up with a child who is so mentally disconnected from the rest of the real world that they begin believing that the only way to solve that problem is to harm other people, and that's never an appropriate thing. In this instance, my sincere hope is that they are able to prosecute, and that if indeed this is a misdemeanor, I hope that they are able to hold this man accountable, and if it involves prison, then prison would probably be appropriate. And if for whatever reason the law is such that he cannot be held accountable, then the Georgia legislature needs to fix that, because otherwise this will happen again, particularly if he escapes accountability here. Now, the young man is not going to escape accountability, but certainly the other people in his life, the father anyway, should not escape it, but they may. Some of you have asked whether or not the individual who committed these acts is going to face the death penalty. He cannot. He's not over 18. Even if he is tried as an adult, the Supreme Court has said that the death penalty doesn't apply until the person is over the age of 18. In many respects, that's a good ruling, simply because the brain doesn't stop forming until you're about 23, I think. So, at any rate, that's what I have for you on the Georgia incident. I hate being oblique about this, but I don't want YouTube to think that I am trying to profit off of a tragedy, because I'm not. But I do want to raise people's awareness. If you have a kid and they are not behaving properly, if they are having difficulty at school, you need to make sure that all of these implements are locked up and kept away from that individual, because otherwise you might find yourself in a true nightmarish situation. That's what I have for you today. Thank you so much for watching. If you have any comments, drop them in the comments down below. Like, share, subscribe, all those things. And of course, if you want, you can email me at the address above. If you have the opportunity today, do a kindness for someone. And then, if you would, come on back, join me down here at the beach, and we'll talk about something else that will be interesting. If you were looking to hire a lawyer, would you look on the beach? Of course not. You'd probably come somewhere like this, where there's law books, secretaries, other lawyers, people dressed in suits. Of course you would. Because if you're looking for law advice, you need to go to a lawyer in your jurisdiction, somebody who knows the law there and who can advise you properly. And don't construe anything that I say here as legal advice. It's just general content on the law.